Hello, everyone, and welcome to the Stern Kessler webinar on Post-SAS Oil States PTAB landscape. My name is Rob Stern, and it's Friday, May 11, 2018. We're broadcasting from Washington, D.C. It's only been 17 days since Tuesday, April 24th, when the U.S. Supreme Court handed down a pair of decisions, Oil States and SAS, that have created considerable changes in the U.S. patent landscape because of the new rules and procedures that the Patent Trial and Appeal Board at the USPTO must deal with. And we're very pleased to be able to share some deep thinking that we have generated over the last 17 days concerning this topic through other conversations that we have had with each other and through conferences that we have been involved in as speakers and moderators. So today we welcome you all to this, and we will be posting this webinar on our website for later download. So be aware of this if you want to share this with your colleagues who are not able to join today. We have a slide deck that you are looking at if you're on the WebEx, so you can enjoy the detailed information there. But we want to have a free-ranging conversation that provides very practical insights to what's going on. So let's go, if we could, to slide number 2. We want to provide an introduction and overview of these two fundamental Supreme Court decisions, then move to guidance from the Patent Trial and Appeal Board, also known as the Board, provide you with some interesting statistical information concerning the great impact that these changes are going to have and are having right now to existing proceedings and future proceedings involving the PTAB. And then we want to get into a detailed conversation amongst ourselves, taking a look at what is going on from several different perspectives, including the patent owner, the petitioner, the board, the Federal Circuit, and the district courts, and then talk about strategic implications and options that we all may want to entertain. So I would like to turn the conversation over to one of my fellow speakers, but let me announce who they are first. We have with us today Deb Sterling, who is the co-chair of our biotechnology and chemical group here at the firm, a very experienced PTAB lawyer, as well as Mike Specht, who is our chair of our PTAB practice here at Stern Kessler, extremely experienced PTAB lawyer. And definitely last but not least is John Wright, who is also a very experienced PTAB practitioner and is co-chair of our appellate practice and who clerked at the Federal Circuit. So John, if I could ask you to walk us through the SAS and Oil States decisions and set a framework for our future discussion.
Sure. Thanks, Rob. Excuse me, I promise not to spend a lot of time going over this. I'll start with Oil States and explain it briefly and then say no more about it because it pretty much left everything as the status quo. We're on slide 4 right now. And then I'll move on to SAS Institute v. Mittal, spend just a tiny bit more time there, but again, the more interesting parts are coming later. So for Oil States, this was a case that challenged the very constitutionality of the AIA proceedings and challenged the constitutionality of the Patent Office's ability to take a patent away from a patent owner. It centered on whether, or the dispute centered on whether a patent is a public right or a private right. If a patent is a private right, then it can only be taken away from a party by an Article III court. But if a patent was determined to be a public right, then what the government gives, the government can take away, and everything would remain the status quo. So the Supreme Court granted cert on that question and issued its decision on the same day as SAS. It was a 7-2 decision, with Justice Thomas authoring the majority decision and Justice Gorsuch authoring the dissent, and he was joined in dissent by Chief Justice Roberts. The majority determined that a patent is a public right, that the IPR proceedings are constitutional, and that the Patent Office can take patents away from people. So the only other thing I'll say about oil states is that Justice Thomas made it clear he emphasized the narrowness of the holding in oil states. He said that this decision does not address whether other patent matters, such as infringement actions, can be heard in non-Article 3 forums. And of course, that's likely referring to the ITC. And also, he said we need not consider whether inter partes review can be retroactive, in the sense that does it impact patents that were in place prior to or granted prior to the AIA becoming law. And he said our decision should not be misconstrued as suggesting that patents are not property for the purpose of the due process clause or the takings clause. So I've heard from our Supreme Court specialists that it's not unusual for Justice Thomas in the decisions that he authors to emphasize the narrowness of the decision. He did the same here. We can take that for what it is. Does it suggest other possible challenges to inter partes review, to retroactivity, etc.? Possibly. So we won't say anything more about oil states. It left the procedures in place. Moving on to SAS, here the court was dealing with the interplay between the threshold for instituting inter partes review, Section 314, and Section 318 of the statute, which says that a final written decision, that the PTAB shall issue a final written decision with respect to patentability of any claim challenged by the petitioner. So prior to SAS, when the board put its rules and regulations into place governing the proceedings, it had interpreted the statutory threshold in Section 314, which says that the minimum threshold for institution is a reasonable likelihood that a petitioner would prevail with respect to at least one claim. And the Patent Office took Section 314 and implemented rules that allowed it to assess petitions on a claim-by-claim and ground-by-ground basis. And as a result, it would routinely issue institution decisions on petitions that institution decisions are what determine the scope of the trial, and it would routinely issue institution decisions that addressed either less than all the claims challenged in a petition or less than all the grounds put forth in a petition. And it viewed its statutory mandate under Section 318 of issuing a final written decision with respect to patentability as covering only those claims and grounds on which it went to trial on. SAS challenged that. The Supreme Court granted cert, and as we all know, in SAS, the Supreme Court struck down the Patent Office's regulation that authorized partial institution decisions. So it said that the petitioner is master of both its petition and of the scope of the proceedings, and that the office does not have the authority to issue partial institution decisions or to institute a trial on less than all claims. That much is clear from the decision. There is also enough dicta in the decision where it could be interpreted as also extending not just to all claims challenged in the petition, but to all grounds. And as Debs will cover next, the Patent Office, as a matter of policy, has interpreted the SAS decision as applying not just to all claims, but also to all grounds. And I'll turn it over to Debs now, and she's going to talk us through the official guidance that has come from the board, both in writing and through a webinar that the chief judge gave a couple days after the official writing came out, or the official written guidance came out.
Thank you, John. So within 2 days, really, the Patent Office had set forth guidance as to how they were going to proceed following the SAS decision. And basically what that guidance told us was the board was going to now institute trials for either all challenge claims or none. But what was more interesting about the guidance was that the board told us what they were going to do with trials that had already been instituted, and that they were going to modify those trials to consider all challenges raised. And as John said, the board took a broader reading of the SAS decision and applied it not only to all claims, but also to all grounds. And the board gave various guidance. We've broke it down into a flow chart here just to make it a little easier as to where you are in your proceeding and what the board is going to do. So really the first question is, are you pre-institution or post-institution? So if you're pre-institution, really going forward, what you can expect for your trial is that it's going to be instituted on all grounds and all claims, or not at all. So it's essentially a binary decision, as opposed to the previous decisions that could institute on fewer than all challenge claims and fewer than all presented grounds. So a quick strategic note here, which we'll get into in more detail later, is going forward, you need to consider this binary decision, the impact it's going to have on related litigation. And the places we can see this impact changing are estoppel and the potential for stays in district court. As I said, we'll touch on that more later, but it's just something that will change in your strategy and your thinking as you're going into these proceedings, based on the fact that it will be an all or nothing decision now going forward. The board then explained what was happening with trials that were post-institution, how it was going to proceed with those trials. And really, if you already have institution on all claims and all grounds, the case is just going to proceed as is, because that's in compliance with the SAS decision. But if you have an institution that was on less than all the claims or on less than all of the challenged grounds, then what the board said it would do, or what the Patent Office said the board would do, is that the board may institute, like sua sponte, order and reinstitute the trial on all grounds and all claims. Now, they may institute this, or they may do the sua sponte order, but not necessarily. So when you get the sua sponte order, and we started getting them within a day or so of this guidance coming out, the board essentially told the parties to get together and coordinate as to whether there would need to be additional briefing, additional discovery, further oral argument, further time needed, for example, and the parties were to get together and coordinate that and come back to the board. And the board did say that if necessary, they could extend the 12-month statutory deadline for issuing a final written decision. If you did not sua sponte get one of these orders, the board guidance did tell you that you can request additional briefing and scheduling on your own. The parties are supposed to get together and work this out. And strategically then, as we said, that those are the things that you needed to be considering. And typically the orders that did come out gave the parties roughly 1 week to get together and coordinate between themselves as to how they wanted to proceed with the schedule. If we go to the next slide, one thing that was interesting that we did not get, this is slide 7, we did not get this in board guidance, we got this through a fireside chat that happened again shortly after the guidance came out. And that was, what are your options if you've already received a final written decision? And here, you know, the panels, the board told us the panels were going to be flexible in terms of extending or waiving deadlines for rehearing requests, and that was the avenue that the petitioner or patent owner should seek to deal with any of these additional grounds or claims that had been instituted if you were after final written decision. And that's really the guidance we got. We have a note here, and we'll talk more about this later. What's interesting is shortly after the SAS decision, and a little bit out of the blue, we got a proposed rule change for changing claim construction from BRI to P.L.C claim construction to look for more consistency between district court litigation, for example, and the IPR, PGR proceedings. And so we see this as an indication, you know, SAS has kind of given the Patent Office a hook to go back and reconsider just how it's been handling these proceedings, and we think we can expect to see a lot more changes going forward. But,
so Mike, thank you, Deb. So Mike, can you provide us, please, with some statistical analysis concerning the impact of this new world on existing proceedings?
Certainly, Rob, and if we could turn to slide 9. First, what I want to do is try to put our arms around the size of the challenge that the PTAB and petitioners and patent owners are facing right now. And what we have done is looked at the pending cases. As you see there, we actually looked at over 500 pending cases to try to get a sense of how many of those cases were partial institution decisions, either on a claim basis or, which is much more difficult to identify, on a ground basis. And we know from the Chief's fireside chat that the PTAB believes there are about 800 proceedings in total that are instituted and pending at the time of the SAS decision. Based on our review of the 500 sampled cases that we looked at, we identified about 44% of those had either partial institution based on partial grounds or partial claims. And thus, by our math, we would expect approximately 350 proceedings to be impacted, where panels will need to go back and go through the procedures that Deb's just identified, where you had partial institution to issue supplemental institution decisions. And now it's interesting to note here, as John indicated when he was summarizing SAS, that SAS clearly held that partial institution based on a claim basis was prohibited, but not necessarily on a ground basis. The PTAB chose, as a matter of policy, to view partial institution based on grounds as being no longer inappropriate. And in doing so, they've essentially doubled their workload in dealing with the pending proceedings, which has put a significant burden on the panels. And that informs and helps us understand how some of the panels are addressing these issues, which we'll talk about later when we talk about some of the strategic implications and your options for dealing with the currently pending cases. So if we could now move on to slide 10. So slide 10 is just a high level. There's been a number of questions. So how will SAS impact institution decisions generally? These are institution decisions, not supplemental, but full institution decisions that have issued subsequent to SAS. There have been a total of 48 of those, and 31 of those have resulted in an institution of the IPR, representing about 65% institution rate. That institution rate is consistent with pre-SAS institution rates. That said, it is probably premature to draw any conclusions from these statistics, but we may start to see a trend where institution rates either go up or down, which is one of the debates ongoing within the industry. All of these decisions make mention of SAS, but the language is non-standardized. And the key point there is not so much that it's not standardized per se, but that each of the panels are doing things a little different, slightly different, and that plays out both in these decisions as well as how they're handling supplemental institution decisions and their approaches to those supplemental orders. And then one question that has been circulating throughout the industry, and at several of the industry conferences that occurred last year or last week, are these institutions, will institution decisions provide less detail as we go forward? Will the PTAB institute on a single ground or single claim, single ground, and explain that and not go into as much detail as they have been historically on other claims? Well, thus far, and again, this is very early, the 31 institution decisions that we have seen are roughly the same level of detail, same length as what was occurring prior to SAS. You see there 29 versus 26 pages, probably not statistically valid, but we will keep track of that and watch that and see how this evolves over time. If we can turn to slide 11. Slide 11 is dealing with the supplemental institution decisions. These are the institution decisions that have issued, that supplement institution decisions that occurred before SAS. And as of May 7th, a couple days ago, there had been 230 supplemental institution decisions that have issued. Kudos to the PTAB for moving very quickly to get those out. There are abundance of them that have issued over the last few days. I don't know what the exact number, but they continue to put these out at a pretty high rate. It is slowing down, and I suspect they're slowing down at this point because they're getting into situations where there are disagreements amongst the parties on how to handle the briefing schedule, on whether or not to withdraw claims, and those cases are taking a bit longer to address. The other point I wanted to highlight on slide 11 is the last bullet here, where we have seen the board has already extended in the supplemental institution decisions final written decision due dates in at least 6 proceedings. This is consistent with what the Chief Judge had indicated in his fireside chat, that there was a willingness to do this, and we see that at least in a handful of cases at this point. One point to note there, through our experiences with panels have indicated that the panel itself is not authorized to extend the final written decision due date, that they must go to the Chief Judge to get that authority. John would like to comment on that point. John?
Yeah, so we've seen at least one grant of good cause extension. There may be a few out there, and it is signed, in this case, by Chief Judge Rushke himself. So just to amplify what Mike said, panels can't do it themselves. They have to go to the Chief Judge to seek authorization, and it's actually the Chief Judge who's signing the orders granting a good cause extension into that time frame.
Thank you, John. If we could now turn to slide 12. Slide 12 is looking at just providing 2 examples of supplemental institution decisions in which they have extended the final written decision due date. In the first case, their IPR 2017-00126, this is instructive because it laid out a full briefing schedule. So I would encourage attendees to take a look at that, to see how the PTAB is laying out briefing schedules. And in this case, they extended the final written decision by a full 6 months, which is to their statutory limit for extensions under exceptional circumstances. The other case here, IPR 2017-00433, this also extended the final written decision due date. The interesting part here, and what I would encourage parties or attendees to look at, is the briefing that was permitted the petitioner. In this case, the patent owner indicated that they were not going to provide a supplemental patent owner response, and the petitioner requested and desired to provide a petitioner reply that would supplement their petition. The board did not permit them to submit additional evidence. That the board indicated that they were grounded in the evidence that they provided in their petition. But interestingly, the board did permit the petitioner to provide a 15-page brief discussing how the evidence in their petition would apply to the ground that was newly instituted in the institution decision. And the board, in return, allows the patent owner here to provide a response to that. So just an interesting nuance in how at least one panel is addressing that issue. And then lastly, just turning quickly to slide 13. Slide 13 is dealing with some statistics, and very few have issued, but final written decisions post-SAS. And as you can see from the slide, there are 20 final written decisions that have issued, 9 of which implicated the SAS issue, that is, that there was partial institution of claims in those cases. And the most interesting part of this is how they've dealt with those cases, inviting the parties to submit requests for rehearings if the parties would like to brief the SAS issues. This is one of the ways, in my view, that the board is trying to stay afloat, if you will, and move these cases forward, essentially forcing the parties to go to requests for rehearing here to argue, as opposed to, in those cases, delaying the issuance of a final written decision and providing parties additional briefing prior to the final written decision. So as you can see, different panels are taking very different approaches to how they're handling these issues. So hopefully these statistics will lay a bit of a foundation for some of our further discussions on the the implications and some strategic options that you may have. So I will turn this back to you, Rob, and you can begin with the industry insights.
So it's very clear that this is a new world that we're in. And if you're not worried about what to do, if you're not focusing on what's going on at the office, then you really need to start doing that now. And the reason for it is that it's a very dynamic, fast-moving situation. What was going on a couple of days ago may not necessarily inform where we are today, and 2 or 3 or 4 weeks from now, it could be different as well. But there are trends that are emerging, and a lot of questions are being asked and debated, discussed, and we want to get into the practical realities of this new world. And if we could all turn to slide 15, we have put forth a few questions that have come up in other webinars, seminars, and panel discussions that have occurred in the last week. And we want to get right into it. So the first thing that I'd like to throw out to our panelists is, what is the practical impact of this new world? Are we going to see more use of the PTAB? Are we going to see more petitions in individual disputes against the same patent? What is the practical reality from a petitioner perspective? Let's look at the petitioner side first, if we could. What do petitioners need to be thinking about if you're formulating a defense strategy to a dispute? You've either been sued or you're being threatened with suit. What should petitioners be asking themselves, and what should be management's questions that should be addressed? So I throw it open to our group. John, what do you think is going to happen?
Well, Rob, you threw out a lot of things there. The first one I'll address is the multiple petition issue. So as many of you know, the Patent Office itself did what it calls its multiple petition study. It was sensitive to the fact pre-SAS that there was criticism in the bar about patent owners being piled on by gangs of petitioners, or having to deal just with multiple petitions on a patent, and on a single patent. So the Patent Office did this multiple petition study, and right around the same time it came out with what I think it's either an informative decision or precedential, but the General Plastics decision that basically gave the factors that the Patent Office was going to look at in determining whether multiple petitions on the same patent were appropriate. And I was talking to a number of judges, PTAB judges at a conference out in Palo Alto, and none of them thought that SAS was going to have any impact on the board's calculus with respect to its multiple petition policy and the guidance that it put out in the General Plastics case. They said that what is still unambiguous under the statute is that the board, even if petitions meet the minimum threshold for institution, the board still has complete discretion on whether to institute petitions, and that nothing in SAS impacted that, and that both the results of its multiple petition study, the guidance that it came out with General Plastics, are not going to be impacted by SAS. So I thought I'd share that just to kick things off.
Yeah, so Rob, I want to focus on more on the question of will there be less petitions filed as a result of SAS? I agree with John. I think there will be less petitions filed as a result of the General Plastics decision and the PTAB's crackdown on serial petitions. But I do not think SAS will or should decrease the number of petitions filed. I think the PTAB process is still the most effective and certainly cost-effective way for a party that's been accused of infringing of a patent to challenge the validity of that patent. Now, to the second bullet point, I think those petitions will be more focused. I think there will probably be less claims challenged in a petition, but I think there may be more grounds put forth in a petition. And I think that's because you need to be more focused on the claims, because you want to make sure if you're filing the petition that you'll get that claim invalidated ultimately, and you won't take a flyer on a dependent claim or a handful of dependent claims that perhaps you might have otherwise. And with respect to grounds, I think you will want to hedge your bets with the first or second ground that you no longer have to worry about the patent office arguing that your grounds are redundant per se, or less worry about that, because they have to institute by a matter of policy right now on all of those grounds. So I think there will be the same number of petitions, fewer claims, more grounds to make sure you win as a petitioner when you file that petition.
But, you know, one of the things that's come out in several things that I've been involved in, webinars and so forth, is some people believe that in order to keep the statistics the way they are, that in order to show that the PTAB is not, this terrible tribunal for patent owners, and to keep the institution decisions down, that it may be that there will be more of a willingness on the part of certain panels to not institute on any of the claims that are being challenged. Do you think that's going to have any impact? Because if you have just one claim that meets this low threshold, you have to institute. And the question is, will the board exercise some discretion? And John, you talked about this earlier. Will they exercise some discretion and say, well, this is a fairly weak case overall, so we're not going to institute at all. And because of that, the estoppels don't apply, and therefore the petitioner, the challenger, can attack the validity in the district court or at the ITC. What do you think about that calculus and whether that might happen?
So I asked some PTAB judges this very question, and they were of the opinion that for all the petitions that are pending out there that were authored pre-SAS, but that are now subject to the post-SAS regime, that the institution rate might fall a bit, because those petitions might have had, strategically a different focus, and the patent owner preliminary responses to those petitions strategically might have had a different focus. And because of that, they were of the opinion that initially institution rates might drop a bit, but that once the the guidance kind of sinks in and we get used to the new post-SAS normal, that things are pretty much going to go back to where they were. Institution rates in the low 60th percentile as parties adjust. So we thought there might be a difference between the two. Deb's throwing her hand up. She might have a different view.
No, I don't have a different view. I was going to say, I think, John, your point was supported by the fireside chat, where one of the options that was discussed in these sua sponte orders that would reinstitute the trials, and one of the options, which we haven't seen yet, was if there was, for example, one or two claims instituted on one ground and the rest of the petition seemed quite weak, there was the option, and it was thrown out as a suggestion that the board may actually, in that case, go back and deny the trial outright as opposed to just reinstituting on all grounds. So I think, that insight that we got from the fireside chat feeds right into what you heard from other judges.
Right. I think it'll be cases where previously the institution would have been on a small subset of the challenged claims, that rather than instituting, that would result in a full-on denial. So that would suggest a dip, as these judges were thinking might happen. But then as we get into the new normal, it'll creep back up.
So what do you all think about the idea that if you compare this process to the opposition procedure at the EPO, where you have maybe 1/3 of the challenge claims found to be unpatentable, 1/3 are allowed or confirmed, and 1/3 are amended. We have seen in the existing PTAB process a great difficulty in terms of any kind of amendment of claims in these proceedings. Practically never happens, even though it was in the statute. Do you think that this may encourage more amendments to occur in these proceedings? In other words, the board would institute, but then become more lenient in allowing the parties to amend their claims, because let's face it, the patents that are in these proceedings are oftentimes some of the most valuable patents out there. Not necessarily bad patents, but patents that are very valuable, but they're going to be challenged because there's so much money on the table. Do you think there's going to be any impact in this regard? Anybody want to comment on that one?
My gut reaction is no. I don't think it changes a whole lot the calculus on why a patent owner would be motivated to amend their claims here, because most of the claims that are going to be before the PTAB are claims that are also before a district court, and parties simply do not want to amend those claims for intervening rights or to create any intervening rights. And I don't think that part of the calculus changes. The incremental change of, well, maybe the PTAB is a little bit more inclined to allow an amended claim, I don't think that would sway me as a patent owner to seek to amend my claim here. Plus, I also think because petitions are going to be more focused, there's going to be less claims in play, and there's going to be less opportunity for amendment for dependent features and dependent claims that ordinarily you might seek an amendment on, but they just won't be part of the proceeding at this point.
So you have the option for a patent owner preliminary response if you're a patent owner. And we've seen that most of the time before this decision, the SAS decision, most patent owners took advantage of filing a POPR. Some even with declarations, though that did not become the norm in any way, shape, or form. So what I would like to ask the panel now is, what impact does this decision have and this new world have on patent owner preliminary response practice?
So I think it's going to change the strategy and the calculus for patent owner preliminary responses. Previously, when I'm representing patent owners, we look very closely at the petition and the grounds and see, is there any way that we can get a claim out of here at the pre-trial phase. That is, get the board to not institute on hopefully at least one independent claim, or if not an independent claim, then maybe one or two dependent claims, especially if those dependent claims have been asserted in an underlying civil action or ITC investigation. that calculus has changed. I don't think, well, certainly it doesn't make any sense to go after dependent claims right now to try and get those out pre-trial. And with respect to independent claims, it's become a lot harder because you need, to address every single ground and every single independent claim. So I think there may be a shift in strategy and preliminary responses over to perhaps influencing the board's institution decision in other ways with respect to claim construction, with respect to maybe procedural issues that could knock the proceeding out, such as real party and interest challenges, etc. So yeah, I think people will likely say less in patent owner preliminary responses right now, especially on the merits.
I totally agree with John on that point. And the other ramification of that is it's going to make, as a petitioner, from a petitioner's perspective, it's going to make it more difficult to prepare your expert for that first deposition after institution, because you won't have sort of guidance from the POPR on where the patent owner thinks the weak spots are in your case, as they're going to focus more on the procedural aspects and less on the merits. And that's going to make it more difficult for that defending that first deposition as a petitioner when you're deposed by the patent owner's counsel.
So we now know that our new director, who is out and about speaking and talking and listening to every group he can imagine. I saw him the other day, very dynamic public speaker. And so we know that the Patent Office is really looking hard at the PTAB process before the Supreme Court decision. And now we said at the beginning of this conversation that it could give them the opportunity to really take a deep dive into the PTAB process. So let's talk about this thing that Deb's brought up earlier about this rulemaking that was just announced out of the blue, and where it looks like we're going from this hard-fought, broadest reasonable interpretation standard that's been criticized in many quarters from day one to the P.L.L.C. standard that's used in the district court. So let's assume that that is going to happen down the line. Talk to us, please, about what we should do. Should we be preparing our petitions using two claim construction standards? Should the POPR be used to deal with claim construction issues? What's the practical reality of having to deal with claim construction so early on in a district court case, for example, when you have that 1-year requirement to file your petition? Let's talk practical realities about claim construction as it's now occurring at the board. Comments?
So I think, typically in a lot of cases, there can be minimal difference between a P.L.C. type claim construction and the broadest reasonable interpretation that we see in front of the Patent Office. And we hear that from some Federal Circuit judges too. They really don't see a distinction there. But there are other cases where there can be quite a difference between a P.L.C. claim construction and a BRI. And those are the cases, I think, if you're considering filing a petition, if you're in the early stage of district court, it does create difficulties because you're trying to figure out your claim construction for your infringement case. And you may, before you get to, having enough information in district court, be forced at the Patent Office to file a petition with a P.L.C. type claim construction or a BRI, or at least figure out what your claim construction is going to be. The proposed rulemaking did say that if and when, and I would expect when over if, these rules go into play, they will apply to all pending proceedings. So really, you have to think 18 months out from now, if you were filing a petition tomorrow, if you were filing a written decision, we're going to have time for these rules to get into place. So right now, you should be thinking about both these claim constructions. Would it require addressing two different claim constructions in a petition? That's really going to come down to a very fact-specific issue.
What if you have an ongoing proceeding and you think that there could be a significant difference between BRI and Phillips in your case? What should you do now? Anything, or should you just assume that you're going to prosecute the proceeding under BRI until the end? Any comments on that?
I think some of it's a timing issue. I think we're probably 3 months away before any new rule putting into place Phillips. There's a 60-day, notice and comment window, and I expect it's probably another month after that before we see the rule. So a lot of it's a timing issue. But if there truly is a difference between Phillips and BRI, and it's a material difference, then I think it would behoove you to address both while you're before the board. You really can't do it in the first instance at the Federal Circuit.
So historically, we have had the same panel of three make the institution decision and also conduct the trial and issue the final written decision. And there's been a lot of criticism about this. One analogy, that is used in using a criminal analogy is it would be like having the same jury on the grand jury as would be in the actual trial itself. So the question is, do you think that the Patent Office, with this new workload that they have, with all the existing proceedings and the new proceedings, do you think that we may be moving towards a system where you might have, say, one judge just making the institution decision, and it would be very bare bones, and pushing all of this further down into the trial itself, and then have a separate panel of three that would be conducting the trial? Comments from our panel on that?
I think I don't know the answer to that specific question, but what I think is clear is that SAS has fundamentally changed the institution practice, and that it has provided a hook or a vehicle, so to speak, for the director and for the board to change its rules surrounding the institution practice. And that is certainly an outcome that has been put out by the bar to the board, and it wouldn't surprise me to see some changes in institution practice, and maybe even changes along the lines that you just put out.
So we have these existing proceedings that are going on, and there's so many there's so many of these. What steps should be taken by counsel on both sides during these proceedings to preserve issues, or to raise issues, or to not waive issues? What should we be doing in that regard?
So Rob, maybe what we should do is turn to slide 17, which talks about some recent orders that the Federal Circuit just put out that will help guide us in answering that question. And maybe, John, you want to address?
Yeah, very, very briefly, let me bring everyone up to speed on what has been going on at the Federal Circuit post-SAS. So court week was April 30th through May 4th, this past week. And SAS came out, on April 24th, I think. So the clerk of the court sent letters to all of the parties involved in cases where SAS could play a role, asking them to be prepared to address SAS at the oral hearing. Then I listened to at least 3 oral arguments at the Federal Circuit, and the panels there set aside time at the start of each proceeding to discuss the impact of SAS on the case. And then after the oral arguments were done, the court ordered additional briefing in a number of cases. So here are the issues that I saw raised at the Federal Circuit by the Federal Circuit judges. So first, they had questions for the parties about SAS's scope, whether it should be narrowly construed to cover just all grounds narrowly construed to cover just all claims, or more broadly construed to cover all claims and all grounds. Second, they asked whether they have subject matter jurisdiction under 28 U.S.C. Section 1295, which gives the jurisdiction for the Federal Circuit. That statute says that they have jurisdiction over an appeal from a final decision of the of the PTAB. So if a final written decision is undergirded by a partial institution decision, the issue is that a final decision still over which the court has jurisdiction, or did SAS ultimately revoke the finality of that decision because it rests on a partial institution decision such that the court no longer has subject matter jurisdiction? A third issue.
So what would be the implications of that?
Well, the implication there is not a pretty one. Appellate courts always have to independently assess whether they have subject matter jurisdiction over a case. And if they don't have subject matter jurisdiction, they can't hear the case on appeal. So if they determine that every final written decision, which is undergirded by a partial institution decision, again, the scope of SAS may matter here, but either on all grounds or all claims, it may rob the court of jurisdiction. And can you cure that, for instance, if both of the parties choose to waive their right to have the new grounds considered? Possibly. But a court itself can't waive the subject matter jurisdiction issue. That's something they have to deal with.
So they would have no appeal right?
They would have to send the case back if they don't have subject matter jurisdiction.
Who would send it back?
The Federal Circuit would send the case back to the Patent Office.
So in all those cases would go automatically back to the PTO?
Right, unless, as a practical matter, the parties maybe could both jointly stipulate that they are not going to, that they don't want to have either the uninstituted claims or the uninstituted grounds considered, and you might be able to cure as a practical matter, this subject matter jurisdiction issue. But I think that remains to be seen.
So we haven't seen them doing this in any case yet?
No. So with respect to the additional briefing, the court ordered simultaneous briefs limited to 3,900 words to be submitted on May 21st. Once that briefing is in, then I would expect the court to caucus. What I don't think is going to happen is we're not going to see panels coming out with decisions in cases on kind of an ad hoc basis, where one panel would say, oh, we don't have subject matter jurisdiction in these cases, and another panel saying they do. I don't think the Chief Judge is going to let that happen.
So, John, when would you expect a decision from the Federal Circuit on that issue?
Well, some of it depends on what they decide. If it's a subject matter jurisdiction, or the next bullet point, if they determine that these final written decisions that are undergirded by partial institution decisions are an ultra-virus act, meaning the Patent Office acted outside of its authority in issuing this final written decision, well, then the cases could start coming back pretty quickly. And it could happen, within a week or two after May 21st, after they get the briefing and have a chance to digest it. Another issue that's on the Federal Circuit's mind was waiver. Did parties have to preserve this issue in their briefs? That came up at oral argument. It is not a question that the court specifically targeted in the orders for supplemental briefing, and I really don't think that waiver is going to be an issue here. It's pretty clear, I think, from Federal Circuit precedent, and in particular their Forshi v. Principi case, that a change in the law from the Supreme Court, brings the issues into play. We don't have to live our lives as lawyers constantly preserving issues that, may or may not come to fruition in the future. So I don't really think that waiver is going to be an issue, except to the extent that a party itself may choose. So, for example, a number of cases, the petitioner had dropped out, right? So what happens if the petitioner has dropped out and the patent owner doesn't want to have the uninstituted grounds or claims considered? As a practical matter, what's going to happen there? Are they going to send the case back to the PTAB and have the board jump into the petitioner's shoes and prosecute the case? No. So, there are practical implications throughout here that the court is going to have to deal with, and I think they will take a practical approach to dealing with it.
And so, John, the bottom line is here, there's a lot of uncertainty, but we should start getting some guidance from the Federal Circuit in early, mid-June, based on this briefing schedule?
I would say early June, mid-June. I think at the latest we'll start, to see the impact here, especially if they determine that the decisions lack finality, such that they don't have subject matter jurisdiction, or if they were ultra vires acts.
So what if you're in the briefing schedule now at the Federal Circuit, and I'm mindful that we're almost out of time, but you're in your briefing schedule now. What should you do?
Well, if the briefing is done, you have the vehicle of a Rule 28J letter. If the briefing is still going on, then you can address and should address the issues as best you can in your briefs, perhaps asking for an extension to see how the court is going to deal with it in these early cases, or motions practice.
So we have a couple of minutes before we're going to close it down. As I always like to do, I'm going to ask each one of you to give us a few thoughts on what's happened, where things are going, what's your practical advice, what's your observation. So let me start with you, John, and what do you want to tell us in conclusion?
So my main observation is that I think the impact of SAS on any given case is going to be highly fact dependent. There's really no per se rules going on here. You have to, it's just highly fact dependent every case.
So you need to be vigilant, though.
Yes.
I see this as basically providing a hook for the Patent Office to go back and revisit how it's been handling these proceedings, and it could create a sea change at the Patent Office. We've already seen the BRI proposed rule, BRI being shifted to P.L.L.C. We could see these changes in panel numbers that you mentioned. Rob, I really do think this is going to be a hook for the Patent Office to revisit the policy and then potentially rules behind these proceedings.
And I would highlight the fifth bullet point on slide 18. I think the board is overwhelmed right now, and in that environment, I think it's really critical that parties, petitioners and patent owners, absolutely know their procedural rights, push the boards, the panels, the individual panels on those issues, and to ensure that you preserve your appeal rights under any circumstance. And finally, my final comment was, you cannot blink right now if you're practicing before the PTAB. It's absolutely critical to stay on top of these issues. They are evolving daily, in fact, hourly on some days. So it's really critical not to blink and to stay on top of all of these issues before the PTAB.
I have just one more thing to amplify on Mike's comments. Once a trial is instituted on a claim or a ground, Section 316 of the statute gives the parties certain rights: discovery rights, right to an oral argument, the right of the petitioner to once file comments, and just be vigilant to the board attempting to short circuit those rights as a matter of expediency.
So we're out of time, but we're definitely not out of issues or things to talk about. We're going to do this again in 4 to 6 weeks. We want any feedback that you want to give us on topics or issues that you would like us to address in the next one of these in this series. We want to keep you on top of all the changes and developments that are occurring at the PTAB and at the Supreme Court. and at the Federal Circuit and in the district courts concerning these big changes. We thank you very much. This will be posted in audio form on the Stern Kessler website, along with our slide deck. Thank you very much, everyone, and we'll be back in 4 to 6 weeks.